Right out of the gate, the judge recaps the previous hearing and reminds everyone that the court already denied the emergency attempt to cut the father off from his child. That detail matters because it tells you the court was not convinced there was enough immediate danger to justify blocking contact. The judge also keeps the existing parenting schedule in place while therapy and related proceedings continue. You can already feel the tension building because both sides are walking into this hearing carrying unresolved accusations, distrust, and frustration. This is not just about custody anymore, it is about control, credibility, and which parent the court believes is acting more reasonably under pressure.
Case number is 20 DM 354. Beginning with petitioner, if appearances could be announced, please.
Your Honor, may it please the court, Desiree Smith appears on behalf of the petitioner, Brandon Daugherty, who also appears. I also have his wife, Rachel Papst, with us.
Very well.
May it please the court, the respondent, Cassie Hall, appears with counsel Jessica Levitt.
Have you entered your appearance formally in this case, Ms. Levitt?
Yes, I have, Judge.
All right. This matter comes before the court at this time for further proceedings. A proceeding was conducted in this court on April the 6th. Desiree Smith appeared with Brandon. Cassie Hall appeared pro se on that date. The court determined that on the hearing for emergency motion to restrain the father from having contact with his son, the court found insufficient evidence before the court to warrant any such orders. There was a Sedgwick County PFA case with other petitioners, was to be heard relatively soon after that date. The court ruled that the father still had every other weekend unsupervised visits. Court ordered allowance of child therapy at the Sunlight CAC. And the court would conduct a review of this case today. Ms. Smith was directed to file a journal entry of those proceedings. Ms. Smith, how do you perceive the current status of this?
Your Honor, the PFA has been set for trial on May 7th. So it was originally set for a docket day where we didn't have sufficient time to do a trial. And so at that date, it was set for a trial date of May 7th. So the PFA has not been resolved yet. The findings have not been made in favor of either party, just moved to a trial date. As far as the journal entry, it is being finalized. I don't think I've gotten it over to the respondent yet, but it should go out today.
The attorneys immediately begin arguing over unresolved motions, delayed paperwork, and accusations that the father was denied parenting time despite court orders already being in place. Notice what is happening here. Both sides are trying to frame themselves as the more cooperative parent while subtly painting the other side as the obstacle. The mother's attorney pushes the idea that unresolved protection order issues and ongoing therapy make it difficult to move forward cleanly. Meanwhile, the father's side wants the court focused on one central point. Parenting time was interrupted. The judge, however, is already looking beyond the drama and toward a bigger question. How do you stop this conflict from escalating further before the child gets caught in the middle permanently?
Getting that finalized. We had an issue with parenting time over weekend where my client was denied parenting time despite the court's orders. And then I believe there's also a pending motion from the petitioner to modify custody with just a regular motion today, which my client objects to.
All right. I'm not aware of the most recently filed motion. When was that filed?
Your Honor, it was filed at the same time that her emergency motion was filed. And that's how we ended up here today. So I believe that motion is before the court today. That was kind of how we got back here.
Is that motion still being pursued, Ms. Levitt?
Your Honor, the motions are kind of tied together as an emergency motion and a regular motion, which of course the court did not grant emergency orders. And yes, at this time, the motion is still being pursued. Unfortunately, I do think that the continuation of the PFA and the fact that therapy is just started does put quite a hurdle in our pathway in being able to fully resolve what's pending before the court.
So what do you propose we do here, Ms. Levitt?
Yes, Your Honor. Well, I will tell the court that since there is no journal entry from the last hearing, and I will apologize if I'm wrong on anything that the court said from that. My client tried to convey to me as accurately as possible as what occurred. And it would seem that at the last hearing, one thing that was made clear by all parties is that there's a fair amount of co-parenting issues between the parties, communication issues, that they are following a parenting plan that is not the same as their written parenting plan, and that there are questions about what is going on in dad's home, what is appropriate rules to set, can mom have a say on certain things or not, or know certain things or not. And those are all issues that we tend to explore in alternative dispute resolution.
And honestly, this is a critical moment because the attorney basically tells the court that these parents cannot solve their issues alone anymore. She points out communication failures, disagreements over parenting rules, and constant suspicion between both parties. What makes this interesting is that the attorney is not just asking for another hearing. She is asking for structured outside involvement from mediators and co-parenting professionals. That tells you the conflict has moved beyond isolated incidents and into a pattern. The court is now being told that unless someone steps in to help manage communication, every exchange, every decision, and every weekend visit could keep turning into another legal battle.
In another form of that, such as co-parenting counseling, when the parties have such a high level of conflict as these two parties have. And I think that unless the court intends to dismiss the respondent's motion, that alternative dispute resolution is literally designed for what these parties have. They previously did mediation with Joy Marlin at Midland Mediation that resulted in them successfully settling their custody issues in the divorce. I have successfully used retired Judge Mike Powers to do mediation, and he does it at an incredibly reasonable rate, $900 for an entire morning 4-hour session to resolve issues. And he'll explore everything from co-parenting issues to parenting time and child support. And Micah Gross provides co-parenting coaching in which if the parties reach agreements regarding co-parenting communication or parenting time issues, she is agreeable to sending that on to counsel for counsel to memorialize. I don't think these parties are going to resolve their problems between each other. I think the court probably got a pretty strong flavor of that at the last hearing, and things have not gotten better. I can delve into some of the issues that have gone on since the last hearing if the court wishes me to do so.
Such as your client's denial of parenting time to the father?
Yes, Your Honor, I can address that. On
Please
the 18th,
do.
I'm sorry, my volume is too low. Could you repeat that, sir?
Please do. Explain
Okay.
it.
Yes, Your Honor. So on the 18th Friday the 18th would have been Mr. Daughtry's next set of parenting time after his 2 weeks prior. Every other weekend is his current schedule. And my client made a request in our family wizard that day prior to the exchange that he let her know where he was exercising parenting time because she had been informed by the parties who have filed the PFA against Mr. Daughtry that their children were at parenting time with their mother and that Mr. Daughtry couldn't be there. He refused to.
The mother's attorney explains that the father refused to reveal exactly where he would be staying during visitation, especially because of complications tied to another pending protection order involving his current household. According to her argument, the mother believed she had a safety concern because she did not know where the child would be sleeping or whether medication requiring refrigeration could even be handled properly. This is where these cases become complicated. One side calls it safety, while the other side calls it interference. The courtroom tension rises because the judge now has to decide whether withholding visitation was protective parenting or an improper violation of the parenting schedule already ordered by the court.
To provide that information, I had just been retained in the days leading up to his parenting time. My legal assistant was out, so my injury appearance was pending, but not filed in E-Flex. So I called Ms. Smith's office to speak to her directly about the issue. Long story short, there was some communication and confusion about who to speak to, and the parties had a conflict over whether Mr. Daughtry had an obligation to tell my client where his parenting time would be. That conflict occurred in the Augusta police station. There was no police officer available to make any report on the same. As my understanding, there was just a clerk at the front desk, so to speak. And my client made the decision that Mr. Daughtry refusing to provide his address and the child being sick, having medication that had to be refrigerated, she did not believe it was safe for the child to go to parenting time. Following that, we received a return of service from the Butler County Sheriff's Department stating that they could not serve Mr. Daughtry at the address provided by my client in her motion to serve him because he now resides at an address in Goddard, Kansas, 944 Long Path Circle. What's interesting about that address, Your Honor, is that's not an address my client has ever received from Mr. Daughtry. Their parenting plan specifically states that both parties are to provide the other their current residential address. My client believed he lived at an address in Wichita. We knew that he was not allowed to be at his address in the PFA if his apparently now wife's children were present. She asked these questions, he didn't provide it. He believes that he only has to provide what he is stating as his permanent residential address, which is not what the parenting plan says. It says current residential address. And yet, when being pedantic and trying to split hairs over what the parenting plan says, we find out from the sheriff that he's not even providing the address where the sheriff knows him to live.
The mother's attorney accuses the father of secretly recording the child, questioning him about the mother's home life, and allegedly trying to create damaging narratives involving neglect and safety concerns. Then comes the bombshell claim that a child welfare report was filed but quickly dismissed after investigators saw it looked more like a custody conflict than actual abuse. This part is incredibly important because judges watch carefully for parents who appear to use investigations, recordings, or accusations as leverage in family court. The attorney frames the entire situation as a ratcheting up of conflict, and that phrase hits hard because it perfectly describes how these disputes snowball when both parents stop trusting each other completely.
We've also had issues since that time that Mr. Daughtry has recorded the minor child while he is interrogating him about mom's house. The child reports that one time he was questioned in the bathtub, another time he was filmed the entire time, another time he was questioned just at the residence. Once was about questions about mom leaving him home alone, which the child had said he had a dream about his mother leaving him home alone, and there was our family wizard communication between the parties about that, where Mr. Daughtry had said, hey, Easton was telling me about this dream that he had where he was left home alone at your house. And my client said that's never occurred. Sounds like he was scared about the dream, kind of essentially like, sorry to hear it, that's concerning, but it's never happened. And then he also asked the child another time to explain to him about how mom's house caught on fire. Miss Hall's never had a house fire. So he's been recording the child during parenting time. He's also filed a DCF report against my client. DCF has already come out, and that DCF report was that my client has left the child alone in the home. My client shared the Our Family Wizard messages with the DCF social worker who said, okay, this is clearly a custody issue. You guys are already in court for this. I'm not doing anything further. And so there is just a ratcheting up of conflict. My client fully owns the decision she made on the 18th in regards to parenting time. She believed that that was a safety issue for her child, concerning that she didn't know where the child was going to be. She feels that Mr. Daughtry is entitled to the same information about her during parenting time if her parenting time is not occurring at her residence. She believes that that is what joint legal custody entitles the parties to, is to know about the child's safety and well-being. But the other issues, the DCF reports, recording the child, asking the child about mom's home, creating a false narrative about mom's home, these are all issues that are not going to go away. And that
the attorney argues that the mother already knew the father's previous addresses and was twisting the situation to justify withholding the child. But then the explanation shifts into something even bigger: fear. The father claims he refused to disclose temporary lodging information because of past violence allegations and concerns that people connected to the ongoing protection order dispute were allegedly watching or monitoring him. This changes the tone dramatically because now both sides are framing themselves as the parent acting out of protection rather than hostility. The courtroom stops being about simple scheduling and starts becoming a case study in total mistrust between co-parents who no longer believe the other side acts in good faith.
Need some outside input or influence, or the court could set the matter for trial. But I don't think I think that just continues to ratchet up litigation and anger between the parties and doesn't teach them the right way to co-parent, which both parties need. I will say that as much about my client as I will about Dad. Both parties have never learned how to co-parent in this case.
Very well. Ms. Smith, your client's reply to this argument that's been made?
Yes, Your Honor. Your Honor, my client disagrees with the characterization of his residence. The address that is on the return of service was his address prior to him moving in with his now wife, and he lived there for quite some time. It's his position that the respondent was well aware of that. There were several months, if not a couple of years.
Actually, the 215 Eureka address, well, I haven't lived there for years.
So that's the address that she sent it to within Eureka. The address that the sheriff said he now lives at was a previous address that he had before he moved in with my client, and so, or with his wife. So she had knowledge of all of those, and she chose to send the notice of service to an old address that he hasn't lived at in a long time. Regardless, he's now appeared for the hearing, so the issue of service is not at play, but he denies that she did not know about that address, and that she was very well aware that he had lived there at one point in time, and she's very well aware of what his current address is now. He did decline.
What is his current address? I presume he has one?
Yes, can you state the address?
1913 Covington Street, Wichita, Kansas.
And that's the address he shares with Miss Pabst. They are married, they reside at that address. Now, it is true because...
So when he was asked for his current address and where the parenting time was going to take place, why didn't he just tell her that?
Your Honor, he did. That is the address she has, but he's not allowed to be at that address when her...
Why not simply tell the mother where the child would be staying? The judge strips away the legal maneuvering and focuses on basic common sense communication. That is what makes this moment powerful. The father's attorney keeps explaining fears, past violence, and harassment concerns, but the judge keeps circling back to one issue: transparency regarding the child's location. And honestly, this is where many custody disputes fall apart in court. Judges often expect parents to rise above personal hostility when it comes to the child's well-being. The court is signaling clearly that refusing simple information creates unnecessary conflict, even if deeper tensions between the adults still exist underneath the surface.
Kids are there because of the pending PFA. So if her kids are at that address when he also has parenting time, when those parenting times overlap, he has to exercise for this 3 weeks of time, he has to exercise his parenting time somewhere else. And so that, I think, was the issue, is that she wanted to know exactly where he was going to be during his parenting time, since he couldn't be at the permanent address for parts of it because her children were there. And he chose not to share that because of a PFS that has happened before between the two of them, and an aggravated assault charge that has happened where Miss Hall has actually ended up putting him in the hospital because of injuries that she caused to him. And so he did not feel safe sharing an address that he was going to be at, due to the fact that she is communicating closely with Miss Pabst's ex, who is running the PFA, and they are using it to harass them and send people to sit outside their houses and those sorts of things. So he did not feel comfortable sharing where the temporary address was going to be, nor did he feel that that was required by joint legal custody, as it is not his permanent address. He has not moved. He just simply has to exercise portions of his parenting time away from the address when Miss Pabst's kids are there. He still lives there. He doesn't plan on moving. We plan on resolving the PFA on May 7th. So this is 2 weekends that would have been affected by his inability to be there. Yet, despite me explaining this to both opposing counsel and the respondent before, I knew she had counsel, she still chose to withhold the child on Easter weekend instead. And so my client doesn't disagree that the communication between the parties is a problem. For example, in that she also said that he had an ear infection, and she did not tell him when she took him to the doctor for that ear infection, or that he...
First, the judge says the father was wrong for refusing to disclose where the child would be staying during visitation. But immediately afterward, the judge also says the mother was wrong for unilaterally denying parenting time because of that refusal. That balance is critical. The court essentially says neither parent handled the situation correctly. Then comes the consequence. The father is granted compensatory parenting time for the missed weekend. This is the judge reinforcing a major principle in family court. Unless there is immediate danger, one parent generally cannot decide alone to suspend court-ordered visitation simply because conflict or distrust exists.
Prescribed medication until a few minutes before drop-off. So she is also not informing my client of medical appointments or diagnoses or outcomes for the minor child. So these parties do have a problem communicating. I believe they likely both blame the other for that. But my client doesn't feel that he should be denied parenting time at this point and would request makeup parenting time for the weekend that he missed. As far as
If it was the intention of your client to just simply take the boy and live under a bridge in Wichita in a tent for the weekend, the mother is supposed to tolerate that?
Your Honor, my client had told her that he had a safe place for them to be, and that
Well,
that was
why
not the
not?
situation.
But I still don't understand the reason why he wouldn't just simply tell her, look, I can't go to my regular house right now because of a conflicting court order, which you know about. We're going to be at this motel. We're going to be at this place. We're going to be staying here for the weekend. Everything's cool. And that's what I don't understand. Because of some past history between those two, he can't give her simple information as to where their son is going to be?
Your Honor, the past history did inform his decision because she's committed domestic violence against him before, and because recently with this PFA, she has been sending people to sit outside the residence and film him and the minor child. And so he has some pictures and photos of that, and so he did not feel that it was safe to share information of where he would be, and he believes that she was using that information solely to provide information to Ms. Papp's ex-husband in the PFA case, which is another problem, that she's involving herself in a case that she is not involved with.
All right. Having heard from both parties, two observations. Number one, the father's reticence, in fact, refusal to inform the mother as to where the boy would be during that weekend was wrong on his part. She has a right to know where her son's going to be.
Both attorneys discuss mediation, domestic conciliation, and structured co-parenting solutions involving outside professionals. What stands out here is that nobody in the courtroom seems confident these two parents can communicate productively without supervision or intervention. That says a lot. The attorneys openly acknowledge the hostility level, and the judge appears genuinely interested.